Good evening, everyone. My name is Vikram Sachdeva. I'm delighted to have presenting this topical webinar no less than three professors of EU law, all of whom are academic associates of Chambers, plus Katherine Apps, who is soon to be appointed KC and is a full member of Chambers. This webinar, which will be recorded, will cover the following topics. First of all, the problem of sunsetting of EU law. Secondly, how retained EU questions are arising in cases from a strategic litigation standpoint, deregulation powers and possible problems of compliance with TCA obligations, and an alternative model, the Financial Services and Markets Bill. Now I'd like to introduce speakers briefly. First up is Professor Katherine Barnard, who is Professor of EU Law and Employment Law and Fellow and Senior Tutor of Trinity College in Cambridge. Next up, we have Professor Andrea Biondi, who is Professor of EU Law and Director of the Centre of European Law at King's College London. Third, we have Professor Alison Young. She is the Sir David Williams Professor of Public Law at the University of Cambridge. And fourth, but not least, we have Katherine Apps, who is a full member of Chambers, and her practice spans public and human rights law, disciplinary and regulatory law, EU, employment and commercial law. Now, questions are to be put via the Q&A, which you will find at the bottom of your screen, and we'll seek to answer those questions at the end. The talk should take around an hour, and we've got about 15 minutes for questions, but those timings are flexible. So without further ado, I'd like to hand over to Katherine Barnard. Katherine.
Well, thank you very much for that kind introduction. It's a great pleasure to be here and talking about this bill. I'm going to be talking mainly about the sunsetting provisions, which Vikram referred to. But before I turn to the sunsetting provisions, just so that everyone's on the same page, I thought it would be helpful to start just by looking at what is retained EU law. So just to remind you that prior to Brexit, the UK government took the very sensible decision to essentially take a screenshot of all of EU law and put it on the UK statute book and called it retained EU law. And the purpose behind that was to ensure that there was a functioning statute book on Brexit Day. The only exception to that was the Charter of Fundamental Rights. That was not carried across. But when we're talking about retained EU law, in fact, it has three legs: retained EU legislation, retained case law, retained general principles of law. And all of that can be found in EUA, the EU Withdrawal Act 2018, and the principle of supremacy of EU law was also carried across. Now, I would just like to say a word about the retained EU legislation, because that's going to be the principal focus of my talk. And the retained EU legislation essentially fell into three buckets. The first bucket was what's called preserved EU legislation, and that's Section 2 of the 2018 Act. And what you see happening there is that any statutory instruments adopted under what was Section 2.2 of the European Communities Act, or under similar provisions in other acts, they would, particularly those adopted under Section 2.2 of the European Communities Act, would have fallen away as and when the European Communities Act fell away. And so they had to be preserved, and they were preserved by Section 2 of EUA. To give you some concrete examples, Working Time Directive implemented using the Section 2.2 powers in the European Communities Act. Working time regulations are preserved. And then Section 3 concerns converted EU legislation. Now, those are measures like EU regulations, regulations with a capital R, and by that I mean EU legislation, regulations, decisions, which did not need to be implemented into UK law when we were members. But again, they would have fallen away had the 2018 not saved them, and they were saved by Section 3. And there's some really important legislation there, GDPR, for example, likewise passenger rights, the compensation legislation if your flight is late. And then there's a third bucket, and that's what I call the sweeper provision. And the sweeper provision is the provision that saves essentially directly effective rights. First and foremost, it saves treaty provisions like Article 157 on equal pay for men and women. And it also probably preserves unimplemented or incorrectly implemented directives with direct effect. Now, all of that counts as retained EU legislation. And what we're seeing with the bill that we're going to look at is that this will be turned off. I'll explain how in a moment. But before I get to that point, the government has done quite a lot of work in trying to map what is retained EU legislation and how much of it there is. And there is the government dashboard, which you see produced there. Now, at the time the dashboard was produced, it was thought there were about 2,400 pieces of legislation. In fact, it was then discovered another 1,400 or so pieces of legislation, pushing the figure up to about 4,000 pieces of legislation. Government has now said that they have identified 3,200 pieces of legislation, and they will update the dashboard as and when they can. Now, with all of this legislation, although some people talk in dismissive terms about it being some sort of red tape that we can do without, if you just look at the dashboard and just type in the word consumer to get a sense of what legislation's at stake, there's some really important rules there. As you can see here, rules on gas safety, rules on provision of food information for consumers, general food regulation. So it's a reminder that the legislation, which goes by the name of rule, is really important. And it's not just sort of techie bits and pieces that we could have done without. So the question is, what is going to happen to it? Now, you might recall that in last summer, or the summer during the election for the Tory leadership, Liz Truss and Rishi Sunak tried to outdo each other on how quickly they would get rid of all of that corpus of retained EU law. And you might recall that Rishi Sunak produced a video which indicated that something called EU legislation would be put through the shredder. And he thought it would all be done pretty much within his first 100 days. Now, all of that, of course, has gone, but the impetus behind the legislation is still there, because the argument is by Brexiteers that, in fact, we have not demonstrated sufficient alacrity in getting rid of all of those 3,000 to 4,000 bits of EU legislation. And indeed, there is some suggestion that only about 200 pieces have been repealed and another 200 or so have been amended since 2018. Now, at that rate of progress, it would take a very long time to cleanse the statute book of EU legislation. So the plan was announced was to sunset the lot. That's the headline. Clause 1.1 of the rule bill. Rule is the name, the shorthand name of the bill, rule spelt R-E-U-L. Clause 1.1 of the rule bill will sunset EU-derived subordinate legislation and retained direct EU legislation. Now, I fully agree that this language is pretty rebarbative, but just to remind you of what I'm talking about, essentially it's this. It's the preserved legislation and the converted legislation. Everything must go under the sunset. And so, for example, in sight, it would be the working time regulations, which is preserved, and passenger rights compensation legislation, cosmetics regulations, which is converted. Now, this does create problems, and I will come back to this in a moment, but just to give you a flavor of some of the problems, that it's all very well saying we're getting rid of all of this legislation, but it will create significant holes in the statute book, leaving aside the rights and wrongs of whether this legislation should be turned off at all. So, for example, the Building Safety Act 2022, which is one of the post-Grenfell pieces of legislation, its definitions in that act are premised on the Construction Design and Management Regulations 2015. And so if you knock away the Construction Design and Management regs, you have an act without any definitions. So clause 1.1 turns off that EU-derived legislation, the preserved and the converted. And clause 3 turns off the sweeper provision in section 4. That's the sweeper provision which gives effect to directly effective treaty provisions and possibly directly effective provisions in directives. So Article 157 will be turned off by clause 3. Now, as you can see, as I've already indicated, this is really a quite striking venture, and it is quite dramatic in terms of the potential consequences. Now, there are some exceptions to what I have just said. First and foremost, it only applies to secondary legislation, not primary legislation. So in principle, the Equality Act 2010, for example, will not be affected by this legislation, the rule bill, even though it implements a large number of directives because it is primary legislation. And the explanation for this is that Jacob Rees-Mogg, who was the leading proponent of this bill until he stepped down at the end of Liz Truss's prime ministership, he thought that primary legislation should be dealt with through other primary legislation and not through a mechanism such as this. But it does create problems because it presupposes that all directives have been implemented in the same way in the different parts of the United Kingdom. And that is not in fact the case. So for example, I've given an illustration there of the Strategic Environmental Assessment Directive transposed in Scotland by an act, but in England and Wales and Northern Ireland by subordinate legislation. So there are problems just in this very crude distinction between primary and secondary law. We're also told in the press release that tax matters and things to do with VAT, excise and customs duties will be dealt with separately. And then, I'm not sure whether it's an exception, but the government has now committed itself to the following 3 things: that it won't weaken environmental protections, that it will continue to honour its commitment to protecting workers' rights in the matter of health and safety, but note not broader workers' rights in respect of, for example, agency workers, part-time workers, fixed-term workers, TUPE, and other things that we know and love. And then it goes on to say, rather cryptically, the government will also take the necessary measure to safeguard the substance of any retained EU law required to operate international obligations within domestic law. And this raises an interesting question whether that commitment extends to respecting the so-called level playing field provisions in the Trade and Cooperation Agreement. The level playing field provisions cover things like the environment and workers' rights. And then the question is, what exactly are those commitments? To take the example of the level playing field provisions in the TCA, it says with the level playing field provisions that if there is regression, then if that regression, that cutting of standards affects trade and investment, then that can trigger the dispute resolution mechanism in the TCA. But what happens if the government decides to salami slice, chop bits off, for example, the working time regulations, but not repeal it altogether? Will that be enough to trigger the level playing field provision? So there's considerable uncertainty as to the scope of what that commitment might be. So a couple of other things. Supremacy is going to go as well. The government says that supremacy is incompatible with Britain's status now as an independent state. The Mar-leasing principle, which is seen as a manifestation of the supremacy principle, also is going to go according to the explanatory notes. And rather paradoxically, the bill introduces a reverse Mar-leasing effect, that if there is a conflict between domestic law and retained direct EU law, then the domestic law is going to have to take precedence over the retained direct EU law. General principles too are being turned off, but it is possible, and Andrea will explain this in a moment, for supremacy to be turned back on, albeit without the EU baggage, and the general principles can also be turned back on, again without the EU baggage, under clauses 12 and 13 of the bill. So there are a number of issues which arise in respect of what is being planned. First is the known unknowns. In other words, we just don't know how much legislation out there which is retained EU law. The very fact that apparently 1,400 extra pieces were discovered, now reduced to maybe another 800 pieces, shows just the scope for uncertainty about how this legislation bites. And remember, the default position is everything must go, even if it's not known that it must go. Now, there was an amendment laid by Stella Creasy and others in the Commons to urge the government, to require the government to list all of the legislation which is likely to be, which will be affected by this bill, but that was not accepted in the Commons. The Lords might try and bring it back. I think it shouldn't be underestimated the sheer volume of work for the civil service, both in Whitehall and in the devolves, and also the workload for Parliament, again, both in Westminster and in the devolves. Just to give you a flavour of how much work this might be, if you look at the 588 or so pieces of environmental legislation, assuming you're going to try and turn off one piece of legislation every day, or at least look to deal with one piece of legislation every day, it would still leave 100 pieces of environmental legislation alone to be looked at and to be considered before the deadline of the 31st of December 2023. There are further issues of democracy, because all of this is really being done by essentially by the executive. It's a vast amount of work to consider what's going to happen, and huge amounts of uncertainty generated. Great scope for litigation, of course, but it is deeply problematic. Now, although I have listed and stated that the default position is everything must go, in fact, there are different ways of dealing with rule, and it is possible for government ministers to decide that they want to keep some of the rule. Now, in fact, it looks like there are 3 or 4 buckets of how rule can be saved. There is a keep pile, a delay pile, a restate pile, and a revoke and replace pile. Now, the keep pile is in clause 1(2), and the keep pile says ministers and the devolves can decide by regulations to keep the existing law. And the key thing about clause 1(2) legislation is that there is no time limit on that legislation. It is potentially indefinite. But ministers have got to be proactive and have got to say, we are consciously deciding to keep X, Y, and Z regulations. If they do not act, then the regulations go. The delay pile concerns the extension of the sunset, but there is a deadline on that of the 23rd of June 2026. Now, the press reporting that some departments, particularly DEFRA and BEIS, want to use this power quite extensively. But there are issues here for the devolves, because the clause 2 powers, the delay powers, are entirely for Westminster and not for the devolves. And therefore, there's real concern that this will cut across the devolved settlement. There is no process in the bill for consultation over whether legislation should go in the keep or the delay pile, nor is there any indication about what the internal processes might be for making those decisions. And remember, if nothing is done, then it will be turned off. Final point I want to make, and then I will stop, that the third and fourth, depending on how you count, way that sunsetting will be delayed, or the effect of sunsetting will be muted somewhat, is that there are extensive powers in the bill to enable ministers to restate retained EU law, or to revoke, revoke and replace, or revoke and replace with something alternative in clause 15. These are Henry VIII powers, considerable power to the legislature, and the detail of that will be discussed by Andrea Biondi. Thank you very much indeed.
Thank you very much, Katherine, for that interesting talk. And now over to Andrea. Andrea.
Thank you very much, Vikram, and thanks for the invite. I hope the slide presentation is there. Katherine did a very good job as usual. So I would simply like to expand a little bit on what she just discussed. And in particular, I'd like to discuss a little bit what she called sunsetting number 3, or if you prefer, the do whatever you like power. I just can't recall exactly where this quote comes from. I think it was a tweet from the Ansar Society, but I'm not sure. But anyway, it just now, we use it as to sort of discuss the sort of powers that the bill is conferring on the government. Now, as Katherine just said, the government can decide to do nothing. That's a law, but also, it can decide. It has a sort of many other different options. And Katherine mentioned Article 12. I didn't put it on the slides, but that's a quite intriguing provision that actually allows the government to restate retain EU law, which I guess that I take it as a sort of the power to translate in a much more user-friendly English the EU jargon, which is a very laudable aim, but it does actually raise some problems about telling, keep on using some kind of EU concept. But I would simply say that probably the most controversial issue, the big thing, is actually clause 15. Why? Because clause 15 confers to ministers and the whole administration the power to do what? To revoke any secondary retained EU law before December 2023. So for any kind of reason, you just want to repeal it now, you can actually do it. And then most importantly, to revoke and replace with new regulations the old retained law, provided that the new rules should actually achieve the same or have similar objectives as the measure being revoked. Now, just one reflection on this point. Clearly, you could simply say, what's the problem with that? You just want to allow the government to keep on improving the quality of post-retained EU law. Nothing wrong with that. And at the end of the day, you still have to achieve the same objectives. But then, obviously, first of all, you have this objective, appropriate. What does it mean? And also similar objectives. And it's quite easy to predict that. What is a similar objective? Can you replace, for instance, hard rules with a voluntary scheme? Would it actually achieve the same similar objective? What kind of benchmark you have to use in order to decide whether you truly achieve a similar objective or not? Is it just enough to show that that was a reasonable solution that within the discretion of the government was appropriate to achieve the same objectives, or do you have to have a little bit of a higher standard? I mean, again, not so easy to determine exactly how this is going to work. And then finally, probably this is the slightly more controversial one. The government has the power to make alternative provisions when they consider that as appropriate. Alternative to what? To EU retain law, to retain EU law. And again, here, am I going to read this provision in light of the previous paragraph? So you still need to try to achieve the same or similar objectives, or is this something completely different? And it's probably likely this is something completely different. And this is really the power to do whatever you like, because this confers really such a wide discretion on government to do exactly whatever they like. So therefore, the first point to make is that clause 15 does indeed confirm wide discretion to the government. And of course, there are other concerns that the Clause 15 future regulation will have to be approved by using parliamentary proceedings that do not actually allow full scrutiny of the parliament. So there are quite a lot of concern on this sort of a possible abuse of delegated powers. Just to complete the picture, it has to be said that also Clause 16, paragraph 1, does even confer extra little powers to the government, because the government is entitled to even to update the Clause 15 regulation if it's if there's a change in technology, or there's a development in scientific understanding, which again, fair enough, seems quite logical, but at the same time, it's pretty broad. It's pretty broad. So first point to make, clearly quite a lot of powers conferred on the government. I think that the most, or at least what I found the most intriguing point is why are we doing this? What's the reason? And I think that's the sort of the answer is perhaps to be found in Clause 15 at paragraph 5, that tells us that yes, you can go ahead, come up with these new regulations, provided that these new regulations do not increase a regulatory burden. So in other words, if you just turn it around, you cannot actually add the new rules and new regulations, but you can deregulate as much as you like. And I think this is quite a straightforward message that is also reinforced if you look at the definition of what a regulatory burden is. And again, if you look at that, the bill gives you quite a lot of examples. I mean, it's actually, as clarified by the government, this is not an exhaustive list. But again, it's pretty wide notion. It goes from an administrative inconvenience to an obstacle to efficiency, productivity, or profitability. Also criminal penalties, there are some limits, but certainly very broad notions. Has to be said that this language is not entirely new. I think it's been lifted from the Regulatory Reform Act of 2006, another act whose aim was to cut red tape, to promote better regulation. Also, funny enough, was one of the aims was also to make national implementation of new law more understandable, more so transparent, and so on and so forth. And if we go back, history repeats itself, because all the, you might actually remember that the same controversy surrounding the role of parliament, the role of government that we are debating right now, it was exactly the same debate when the regulatory reform bill was actually introduced. So more or less this sort of full circle. Now, as I said, the language is the same. If we go back to the Regulatory Reform Act instruments, then in reality, I think that we had around 40, 50 of this sort of cutting red tapes instruments. But then if you look at the specific instruments, mostly they deal with rather small matters. There's one about improving the licensing system to sell alcohol at charity events, one about licensing, what kind of license you need to get if you want to keep wild animals. So pretty small matters. But obviously, if you transpose this new test to the retained EU law, well, that's a different matter. And I think that Katherine explained it very well. Retained EU law, and how can I put it? I mean, clearly the bill here is just a little bit based on a sort of slightly cliche idea of EU law. EU law is bureaucratic, it's only about small technicalities, it's boring. But then again, as Katherine explained very well, it's much more than that. Retaining EU law is about consumer protection, it's about fundamental principles, about protecting rights. So I'm afraid it's hard to simply yes, of course, European law is also bureaucratic and sometimes even too technical, but it's a bigger picture than that. Further, if I may, again, this idea, this model that the Clause 15 put forward sees good regulation as only deregulation. And of course, the regulation is much more than that. It's about ensuring the proper, a proper process for pursuing public policy. So I don't know, I found this just a little bit problematic. And actually, it might be, even paradoxically speaking, might actually, sort of this new Clause 15 regulation might also somehow make it more difficult for the government itself to pursue its own targets and policies. Not to mention that you might sort of exacerbate even possible differences and tensions with the involved regions. Very quickly, if I may, now on a sort of last point. I think that good regulation. I think there are some universally accepted principles of good regulations. For instance, effectiveness, the fact that you have to subject a new regulation to a strict economic analysis, that you have to consult stakeholders, that you have to rely on expertise. And actually, probably it would have been much better if the Retain EU Law Reform Act included this kind of guarantees before the government can actually adopt these new sweeping regulations. But that's a different point. My point was, it's also widely recognized that good regulation means compliance with international standards and international agreements. And of course, I'm not suggesting here that the bill can violate the UK international commitments. Far from it. And actually, the government, on the one side, strongly reaffirmed the fact that, of course, the bill is not going to make any, it's not going to affect, for instance, the withdrawal agreements provisions. So, for instance, EU, the EU citizens' rights are not going to be affected, and so on and so forth. And further, as Katherine mentioned, there's been a sort of official commitment of no lowering the standards on environmental law, for instance. However, I think it is still important to ask the question whether in reality, should we call them Article 15 measures, Article 15 regulations, could be a little bit problematic from the perspective of the TCA. And this is a little bit of a general problem, which I found when you're looking at post-Brexit measures. Whatever you say, they're not there in isolation. I mean, the area I'm working on, the Subsidy Control Act. The Subsidy Control Act is a massive piece of legislation and really important one, but it's a sort of a direct consequence of the obligations imposed by the TCA on the UK. And if you look at the whole act, I think the TCA agreement is mentioned 3 or 4 times, which is a little bit strange. And I think that, again, it's not possible to see the Retain EU Law Reform Act in isolation. It has to be questioned whether there might be problems if you look at the impact that this kind of measure might actually have on the commitments that the UK undertook under the TCA. Now, obviously, and again, it looked like ages ago that we had this discussion, but one of the most important, if not the most important part of the Trade and Cooperation Agreement is that part devoted to ensuring the level playing field, whatever it means. But said that there's a huge, it's a really substantial part of the TCA. And in particular, the TCA does actually impose a certain kind of, there's quite a lot of, not only just substantial rules on the specific areas of how to maintain level playing field, but there are specific remedies and specific enforcement tools to keep on maintaining the level playing field. And in particular, as Katherine mentioned, the TCA, for instance, require the parties, the EU and the UK, not to, there's just a series of non-regression clauses. That is to say, the UK and the EU should not actually reduce the levels of environmental or climate protection, labor standards, subsidy control, state-owned enterprises protection below those standards that were in place at the end of the transition period. Plus, the TCA also allows the parties to trigger the so-called rebalancing clause, which is actually a sort of remedy if there is a significant divergence of standards. One of the parties can resort to these instruments. And of course, I'm not suggesting here that this is going to happen. And again, there's a lot of, again, probably don't have the time here, but the how to trigger a non-regression clause, how to trigger the rebalancing clause is subject to so many constraints that might actually be unlikely, because you need to prove, for instance, that there's a material impact on trade and investment, which is a quite high threshold and stuff like that. But I'm not. But at the same time, it's not impossible. It's not impossible. Things can change very quickly. And here I just like to finish with one example, which I'm not saying that this is going to happen. But if you take, for instance, some of the sort of flagship initiatives of the government, free ports or investment zones. Free ports, they usually get quite a lot of bad press, but just let's use an example. Again, you have free ports that might be problematic under three headings. First of all, because usually you apply different kind of, it does actually, free ports, they're actually subject to different kind of tax rules, certain kind of tax incentives and stuff like that, that might be problematic under the subsidy chapter of the TCA. They also, there's always been a little bit of concern about labor standards and free ports in terms of union representation, things like that. So again, this might be problematic under the labor standards of the TCA. And also, there are specific rules concerning planning or impact assessment that again could be problematic for environmental and climate protection standards under the TCA. So you see that if you start thinking about it, well, I'm not saying that again, it's likely, but I think that it's important to keep in mind that once again, the retained EU law bill is not there in a vacuum. You really have to take into account also what kind of obligation that the UK has towards the EU and generally speaking in the international sphere. Thank you so much.
Thank you very much, Andrea. We'll have to discuss afterwards the known unknowns, and perhaps we'll even have time to talk about the unknown unknowns. But without further ado, I'll hand over now to Alison.
Thank you. If I can hopefully get my slides to share, then hopefully that's up for you. So what I want to do is to move on to looking at another possible way. I think what we've seen with the retained EU law revocation and reform bill, that there are various problems it can give rise to, and Katherine has pointed out the problems that arise from the sunsetting provision, how difficult it might be to find all these laws, the legal uncertainty, the workload, and also the element of democracy, which I think Andrea has really built on in explaining the ins and outs of the problem, of the extent to which there can be sufficient and adequate democratic scrutiny of these new measures that will come through in order to replace the measures that we used to have as part of retained EU law. Now, the retained EU law revocation and reform bill is not the only bill in town that's going away and looking at the idea of removing retained EU law and replacing it with something else. So what I wanted to do was draw your attention to another bill, which is also going to be provoking other aspects of the revocation of retained EU law. And this is the Financial Services and Markets Bill 2022, which is currently working its way through the House of Lords. And as you can see from chapter 1, the first thing that it is looking at is this idea of revoking retained EU law. So it's not just the general provisions, there are also sector-specific provisions coming through. And what I want us to think about is this a better or worse example, and what lessons can we learn from this particular method of removing retained EU law? So what the Financial Services and Markets Bill is doing is in Chapter 1, it is setting out various aspects of retained EU law that will be disappearing, that will be removed. But it isn't just saying, here's some retained EU law, all of it is going to disappear. Instead, what it does is it sets out in Schedule 1 a list of all of these particular measures that will be being revoked. And this is then divided into the retained direct principle EU legislation. So all those measures that we're looking at that were enacted by the EU and that were transferred across to become part of retained EU law. It's also looking at subordinate legislation, so measures we will have enacted to bring in aspects of EU law. It's also looking at aspects of EU tertiary legislation, primary legislation that have been implementing it, and then a catch-all provision of other EU-derived legislation, and also the provisions that have direct effect. So it's trying to think very carefully about what types of retained EU law are there out there in dealing with financial services and markets. It's then trying to list them all and set them all out in a schedule. Now, this does mean that the bill, once you read the bill and the schedule, is very, very long. But the big advantage of that is obviously it is those provisions listed that are those that are going to be revoked. And this then deals with this problem of the known unknowns. Instead of having a known unknown of what EU law is going to be disappearing, you have a schedule that sets out what aspects of EU law are going to be disappearing. So it doesn't necessarily deal with the problems of the workload issues, but at least it gives an element of legal certainty and clarity that might help us move forward to work out which provisions might be disappearing and how might they be being replaced. So how do we then move on once we know things are going to be disappearing? Well, rather like we find in the Retained EU Law Revocation and Reform Bill, the vast bulk of this will be being replaced by delegated legislation. And we have the same kind of abilities to rescue measures that would otherwise be revoked. So the Treasury can go away, look at this long list and think, well, actually, we want to rescue this provision, not the other provision, and this can then be moved to make sure that those are not removed. We also have the same ability of ministers to be able to restate those provisions that would otherwise be revoked. So that ability to go away, look at a provision, decide, well, actually, we think this particular provision is quite sensible, so we will restate it, in a sense, showing that it's got approval of the UK, because the UK minister has gone away, looked at it, decided this is sensible, and so is restating these particular provisions. So all of this is all well and good and seems to be giving you the ability to replace things, but it's still giving rise to the same kind of problems of how far is there going to be democratic scrutiny over these particular measures. The other big difference is there is no sunset clause. So instead of it being a system whereby you say all of this law is going to disappear by a set date, unless it's gone through this process of being restated or is being removed and exempted, instead you have a provision where you say, hey, everything here will be disappearing at some time. But instead of sunsetting, it's all being done through commencement provisions. So the particular provisions that remove all of these provisions from having effect in domestic law don't come into force from the moment the bill becomes an act. Instead, there's a commencement provision that allows ministers to decide when to bring the provision into force. So it's like a reversing of the sunset. Instead of it being they're all going to disappear by a set date, instead there's a list of things that will be disappearing, but we won't know the date in which they will be disappearing until the commencement provision is enacted, and the time can start ticking. And you'll know it's on that date that all these measures will no longer have effect in domestic law. The other difference is it has this element of what they're calling transition arrangements. So between the bill becoming an act and these particular provisions that will remove legal effect of all these aspects of retained EU law, there is the ability to have these transitional arrangements. So this has this ability for where the Treasury can go away and have a look at these particular provisions and decides, is it going to modify any of these provisions? Is it going to restate them? Is it going to rescue them? And there's this element of a default affirmative resolution procedure for these measures that will can then come in and modify the provisions of retained EU law, apart from in situations where you're changing aspects of EU tertiary legislation, or when you're dealing with retained EU law that was implemented through subordinate legislation of the UK, and then you have negative resolution in these particular circumstances. So it's a different way of trying to think through these particular provisions. And I'd like to suggest that there might be some lessons we can learn from this particular way of thinking about it. I mean, I guess the first thing we need to think about is if the retained EU law revocation and reform bill is not the only bill in town, then we also need to be thinking very carefully about what other bills may be coming through, particularly with regard to those pieces of bills that will be dealing with EU law that was brought in through primary legislation, and how they will all interact and how they'll all slot into place. I'd like to suggest that having a schedule listing those provisions that will be disappearing might be able to give more legal certainty than relying on everything is disappearing, but we're not listing it, and let's hope we find it all and list it all and we can know what it is. So yes, it's a lot more work up front to go away and find all of these and list them, but at least in that case, if you accidentally forget a provision, it doesn't disappear and be removed, it will still be there. But obviously, when you're aware of this, then there's the ability to go away and deal with it later on. So I think this is a way of perhaps giving a little bit more legal certainty than we find through other measures. The other possible advantage you have here is that it's sector specific. So it's about an element of looking at EU law, retained EU law in one particular area. And I'd like to suggest that this can be a better way of thinking about this, because if you've got an oversight of all the different measures in a particular sector, it gives you an ability to think about how they all interact, how they might interact with other areas, and to think more carefully on that sector specific basis about which provisions you think work, which provisions you think don't work, and how you go through the process as to how you're going to potentially retain them, revoke them, change them, modify them as you move forward. Also, I think there's some kind of suggestions of saying that if it's sector specific, you could think much more carefully about what kind of democratic oversight you need over this particular area. So when you're dealing with very technical areas, you might want to argue that it's better to have experts looking at this and proposing measures. But when you're dealing with broader measures, then you can argue there's a need for more parliamentary oversight in those particular instances. So being sector specific might be a way of also thinking more carefully about how much democratic scrutiny is needed. Another element that comes through these particular provisions is this element of thinking about consultation. So here there was a prior consultation process of the future regulatory framework review. So having this kind of element of before all these measures might get revoked, having a consultation element, talking to people working in that sector, thinking about what provisions are working, what are not, putting proposals forward and consulting can again hopefully provide a process through which you can think much more carefully about what measures we want to keep, what measures we want to change, and what measures it's safe to be revoked in particular areas, and also think much more carefully about how to get a particular sector working when we think about moving away from being within the EU into the Brexit situation and what particular measures we might need. The other element that I think is really helpful here is that there's a recognition of the fact that you might need time to think through these particular transitional arrangements. So I've given you a quote there from the explanatory notes that are attached to this particular bill, where it says that the government expects that it will take a number of years to complete the process of revoking retained EU law. Therefore, it is likely that some elements or specific provisions within retained EU law will become ineffective or out of date before the revocation is commenced. So at least this kind of element of recognizing that this isn't necessarily something you can do quickly. It would be nice if we could think about that more generally, perhaps, and thinking about how much time is needed. If time is needed to think carefully through regulatory frameworks and to think about when things might become ineffective or out of date, which again is going to cause all sorts of problems long term as all these different provisions interact. And I think time is also needed when we're thinking more generally about removing issues. So it isn't necessarily an ideal process, And there are still some huge issues thinking carefully about how much democratic scrutiny there might be over new provisions as they come through. But I think it gives us pause to thought to think about, are there other ways of achieving this that might answer some of the problems we've pointed out, but it also gives us pause to thought to think about the fact that the retained EU law revocation and reform bill is not necessarily the only current bill in place, and perhaps might not be the only piece of bill we can expect to be coming through that will be dealing with the revocation of EU law. So we need to be looking out for these new bills and thinking about how they all interact with each other.
Alison, thank you very much for that. If that's the end of your talk, it is, right. Now it falls to, I think you're muted, actually. Now it falls to Katherine Apps to complete the talk. Over to you, Katherine.
Well, thank you very much, Vikram, and thank you so much to Katherine, to Andrea, and to Alison for those really, really interesting talks. What I'm going to do, and I apologise in advance for my voice, I'm a little hoarse today, is to talk from a practitioner perspective. Now, I'd hoped to be able to say a little bit more with a bit more specificity as to how these types of issues are coming up in the types of cases that are crossing my desk. But because so many of those are pending before courts or at a relatively early stage, I'm rather limited as to what I can sort of say with some specificity. But what I'm planning to do is to distill some key points and looking at it in sort of 3 time segments. Just look back very briefly to that pre-Brexit era, then talk a little bit about the time post IP completion date, so after 31st of December 2021, and then to talk about the future and the provisions that are in these bills in draft. I'm going to use the phrase my clients. I'm not talking about literally every single one of my clients. So if you're one of my clients on the call, please don't worry, I'm not actually going to be talking about your case specifically. I'm also very much not talking sort of as the client's mouthpiece as I would be in court, but I'm using that phrase on an anonymized basis to raise the types of issues that are crossing my desk and to give a little bit of practical color to how these issues, or how I see these issues playing out. And I should say that everything I say is from my own personal perspective, and it's not that of my clients, and it's not that of my colleagues in chambers. So looking at that first time point, pre-Brexit, the client perspective, or the client perspective I saw pre-Brexit, was that an EU, a special euro point, might be worth the client's while to make if it did one of 2 things. Either it would simplify, so it would cut through lots and lots of detail and different ways of arguing things, because the answer would become clear because of the EU derivation of the particular right or duty, or it would complicate matters. And the simplification, it might come from a right having direct effect, so having the power to blast through primary legislation. It might come from the Mar-leasing principle, so the principle of consistent interpretation. And I found, particularly in the areas that I did, that this would often simplify things if there were several different constructions of either primary or secondary legislation. And particularly in areas where there's more than one piece of legislation or sectors kind of colliding on the facts of a particular case. And looking either at the directive or the treaty principle, it was often possible to get a degree of simplicity in terms of what the whole point of the legal regime was to be. And that could actually save quite a lot of time, because if you had that, that would drive through, as I said, all of the other kind of noise and detail. The other area where it could be useful in cases against the state, I sometimes defend the state, but in cases against the state, it is where ultimate overall responsibility for compliance with that EU obligation lay with the state. So the exact way in which it got there might not matter so much as the fact that you knew you had the right defendant at the end of the day. I also, and I know there's a controversial view, found that in cases where there was a cross-border element and maybe a conflicts of laws element or a jurisdictional element, that there was a degree of certainty that came from the sort of canny new way of regulating a particular sphere. Now, on the flip side of it, complication could potentially be in a client's interest in, I think, broadly 3 scenarios. The first is the well-known one of defending summary judgment. If you could show that there was an evolving area of law, and EU law tended to evolve at a really quite rapid pace, particularly some areas, then that was your golden bullet for actually defending something that could either knock out your case or, depending on which side of the line you were. The second point is in combination with the first, where if you're able to put your client's case simply as being driven and there's no real other option because of EU law, but in order to argue the contrary, your opposite side would have to delve into all of the detail. That's where complication could be quite useful. And then, of course, there were some clients for whom actually extending the process of litigation itself was in their interests in terms of running down the clock. And because of the process of going to Luxembourg and back again, that could for some clients be a helpful outcome. Now, turning to the next stage, next time stage, post-Brexit, we then had to deal with the European Union Withdrawal Act, or EUA as some people call it. And what that produced was, in some areas, some completely slam dunk points. And as Katherine Barnard has explained, the principle of supremacy in a large number of areas was actually maintained, as was a lot of the legislation and that leasing principle of the reason for that legislation. I've seen three things from the period of litigation that's followed that. The first is that while a lot of the discussion pre-Brexit about EUA was about the provisions that dealt with retained EU law, and that sort of very much sort of caught the public consciousness, a lot of the litigation since has been either won or lost, not to do with EU law, but because of the time period that litigation has related to what was in the withdrawal agreement. So the obligations that the UK agreed to keep during the transition period, and what the withdrawal agreement then bound going forward. And there's a whole lot of the EUA Act that deals with relevant separation agreement law. The second thing I spotted is that there's actually interesting but also quite difficult case law and argument about retroactivity. So this point about the time point, and this touches a bit on what Alison was discussing earlier in terms of the markets bill. The transitional provisions and the time point about what law is going to apply to what facts and what claims and what rights at any particular point in time is, again, very important if you have facts of an individual case, because those provisions will depend on whether you can actually run the point or not run the point at all. The other point is that the trade and cooperation agreement, so Andrea was discussing to a great degree, that has started to become the new show in town, and that if you can pinpoint a right or an obligation that is mandated by the trade and cooperation agreement that in some respects is directly incorporated through the relevant statute, or currently at least, into English law, then that enables that same structure, that same type of argument as used to be able to be run while the UK was a member state of the EU. There's two areas where I think EUA has been causing particular difficulty, and that's related to the leasing point. And this is where you have an area of domestic law or regulations or whatever EUA has done to retained EU law that then lifts off from its foundation, so that the driving principle of what it was there for. And that's where I foresee some difficulty with the structure, to be honest, both new bills, in terms of how it deals with legislation that is left in the detail, but the driving force of why it's there has become removed. And I think that becomes especially complicated in areas where you've got two areas of legislation that are butting up against one another in a particular dispute. And the other area is related to the point about retroactivity, and that's what happens to do with those Walker and Innerspec type cases. So what is the source of the right or obligation that is being interpreted? Is it EU retained legislation? Is it EU retained case law? Is it domestic case law that interprets a directive? Is it general principles of law? And under EUA, those different routes go down different legislative provisions and can, in some quite narrow circumstances, produce a different answer. Now, the answer to that kind of difficulty in this pre-bill but post-Brexit scenario was it would be ideal if in your particular case, you could actually agree with the other side what the ultimate outcome was. Does mar leasing apply or does it not? And the actual route by which you get there doesn't really matter. But the way that these bills have been structured and the proliferation of different types of legal thing that's there, or legal protection that various bits of delegated legislation can either have or not have, makes that route tracking particularly important. And I foresee more cases where that analysis, the cold towel analysis of working out what exactly it is that you're arguing, what exactly it is that you're relying on to make your argument work, how that actually works through these legislative provisions. I was looking at the retained EU law bill. I was trying to work out how is this actually really going to, what is this really trying to do? You know, thinking what's the best analogy for it, and the best analogy I could come up with was that it's kind of like having an analog watch but wanting an Apple Watch. And Apple Watches don't have any cogs inside, so you take out all of the cogs from inside your analog watch. Now, if you just do that, you're not actually going to have anything that tells the time whatsoever. You have something that has no cogs, but it's not an Apple Watch. Now, what you can do is you can put a digital mechanism in it and make it into a digital watch, but using the same casing. Or you can put slightly different cogs in it, or you could put some of the old ones and some of the new ones in. But the process of doing that is very, very precise. And you only have to make 1 millimeter of error to produce something that doesn't work. And I think that's where we are at the moment in terms of the legislative task that's facing these two bills in terms of putting them together. So drawing it all together then, the three lessons that I've taken from the Brexit related cases that I've done so far is firstly that the point about they work if you can find a clear answer, possibly by different routes, but that you can produce something that has that characteristic of clarity and simplicity that it was sometimes possible to do under the old law. The second point is that if you can't do that, then actually things have to be explained in quite a lot of detail, usually better, I think, in my own mind, to do that written rather than orally, to trace through those different routes to those slightly different ends. And then thirdly, the real impact of this type of change tends to end up being that those who sort of come out all right at the end of the day are those with power, by which I mean money power, to be able to afford the lawyers to work out what it is that the answer is, and to see through litigation if that is needed. Now, I say that with a big caveat because, of course, being a barrister and doing cases in court means that we often see the law with sort of litigation spectacles on. Whereas, of course, in the areas that are covered by these two bills, by and large, happy clients don't litigate at all. The best thing you can do for a client, I've always thought, is try and keep them out of court, if at all possible. And that's where those three thoughts deal with litigation, but what they don't do is to explain how one can actually create a situation where there is that certainty for businesses, for individuals, in terms of knowing what the rights are. Because if people don't know what the rights are, then they will only fight in circumstances where it's existential to the business, or if they have pots and pots and pots of money. So I don't want to be terribly bleak. I can see ways that this can work, and something obviously is clearly going to happen in both of these, in relation to both of these bills, and there's of course politics as well as legal drivers. But the devil really will be in the detail, both of the individual provisions in the bills and any subordinate legislation, but also in relation to that structure of what actually the purpose is going to be for. So with that thought, I'm going to hand you back to Vikram, and then we can deal with any of the questions that have turned up in the chat.
Thank you very much indeed, Catherine. That was fascinating, as have the other talks been too. We have one question in the chat so far, which I think turns partly on what the Conservative Manifesto, which proved successful at the last election, said. And that said as follows: once we get Brexit done, Britain will take back control of its laws. As we end the supremacy of European law, we will be free to craft legislation and the regulations that maintain high standards, but which work best for the UK. We want a balance of rights, rules and entitlements that benefits all the people in all the parts of our United Kingdom. obviously a persuasive message. And the question is that there's been discussion that the Lords will not be able to vote against the bill because it's a manifesto commitment, particularly the reference to supremacy of European law ending. And there's then a question about whether supremacy has ended, whether it ended when we left the EU and revoked the ECA 1972, or whether it still continues. Does the panel have any views on whether the bill is a manifesto commitment, and who decides if the Salisbury Convention applies? Very interesting question. Alison, can I ask you to consider what your answer might be first before I ask the other members of the panel?
Thank you, Vikram. It is a very interesting question and isn't necessarily an easy question to answer, because there are some in the House of Lords who would argue that they aren't even bound by the Salisbury-Alison Convention because it wasn't necessarily agreed when their party was in existence. So trying to get any kind of element of clarity as to what this convention is and as and when it applies isn't necessarily easy. I think that the shortest answer I can give without getting myself into trouble is that I don't think when we look at what the House of Lords can and can't do, they are necessarily going to be thinking about, can we vote down an entire piece of legislation? So I think whenever you bring something through the Lords, they are thinking very carefully about what is it justifiable for them to do. And they tend to see their job much more as scrutinizing provisions and raising problems and perhaps suggesting possible amendments that might be picked up than necessarily voting against it writ large. So even if the convention wasn't applying, it's very rare to have a House of Lords that's going to be motivated enough to say, right, sorry, no, not voting for this at all. So I think the real issue is going to be what, if anything, what can we sort of expect in some senses from the kind of scrutiny that the House of Lords might be giving. So this is where I have to disclaim my liability as a legal advisor to the Constitution Committee. So I cannot tell you anything that may or may not be in their report, but I can tell you that the rules of how things go through the House of Lords is before it gets to committee stage, there will be, if the committee feels there is a need to produce a report from the Constitution Committee and a report from the Delegated Powers and Regulatory Reform Committee that will set out various issues to do with the bill. So the Delegated Powers and Regulatory Reform Committee will focus predominantly on what delegated powers have been given, and do we think there's a justification for them? Are there any problems that arise? And the Constitution Committee will look at other constitutional issues. So it will be open to House of Lords committees to produce those reports, should they wish to do so. It's open to members of the House of Lords to then act on the information in those reports, should they wish to do so, and possibly propose amendments. The other thing to be aware of is timing. Timing is crucial because obviously two clocks are ticking. One clock that is ticking is the parliamentary session, because if you don't get this through before the end of the parliamentary session and then pass it over, you're in difficulty. The other clock that is ticking is a sunset clause provision. It's ticking down. So if you want to be able to achieve all these in the timing of the original sunset clause, then you want your legislation to be passed earlier rather than later. And that might give a little bit more leverage in the House of Lords for them to suggest possible amendments that might be very useful to have if you want to get this passed through quickly. So I think don't necessarily write the House of Lords off, even if some of them think that the convention applies. And whether the convention applies is kind of sort of hard to say. Who decides that is probably the safest thing I can say without getting myself into huge amounts of trouble. So as much as I'm able to say, I think the House of Lords might be able to do slightly more in terms of proposing amendments given the timing issue. But I don't think the House of Lords would ever really, even without the convention in place, think, let's just vote against it completely and get rid of it.
Thank you very much, Alison. Does anyone else have anything to add to that answer? Or are we generally content?
Also, I think that it's quite clear that some of the members of the House of Lords already clearly said that there are some of the issues where, for instance, what we just discussed, the extent of delegated powers, where they really feel that they had to intervene. So that we had quite a few statements that they feel that is really important to fulfill their duties as a sort of scrutinizing the legislation, the bill.
Right. Okay. Anything else from anyone else, or should we move on to the next one?
It is just worth thinking about what the House of Lords might do and might want, because even if they were to say, well, we should change clause 2 and say it should go to 2030, for example, as opposed to 2026, whether that would help a great deal. Yes, it takes you to the other side of the election, and that might be a political factor that comes into play. But the reality is that the use of clause 2 just defers the day for when all of this comes to an end, which doesn't actually help in terms of investment certainty, because if you're going to invest, you want to know what the law is going to be in 5 years' time, and just deferring things really just creates further difficulties. So there may be a group in the Lords who just want the bill stopped altogether because they fundamentally oppose it. But that really would be quite a dramatic action. So if they don't go down that route, and of course they're minded of their constitutional position, they may well say, well, we can try and trim it here and there. We could try and get a bit more affirmative rather than negative resolution. But ultimately, it doesn't address the fundamental question. You're either for or against this bill. If you're for this bill, then you see not a great deal wrong with it. If you're against this bill, tweaking it is not going to deliver. If you're against this bill, you want the whole bill stopped. And that's a very big political step for the Lords to take.
Yeah, I can see that. All right, well, I've got a question for you, and it's this. I can see that there is a principled reason for supporting a bill of this sort, and that is because one of the reasons that Boris Johnson won what must be termed a thumping majority at the last election was his promise to get Brexit done. And one can see that if many of the laws we're still following originated in the EU, some people would think that Brexit wasn't quite done yet. So I can see the legitimacy of the principle. But against that, there seem to be arguments both of principle and of practicality to not do it this way. Principle, because it's really very alien to the British approach or the UK approach of looking at individual bits of legislation individually and deciding whether to repeal or amend them, rather than doing it in one fell swoop without really knowing what's in the bucket. And secondly, practicality leads to both great deal of uncertainty, as the Director General of the CBI has recently commented, and whether there's civil service bandwidth, having done all the Brexit-related legislation. There are a few other problems at the moment, aren't there, about the NHS and the cost of living and Ukraine that may also take some time to sort out. I just wonder what the panel think might be the pros of still continuing to proceed this way, because I think we've set out some of the negatives. Can you think of any pros of doing it this way, or is it really quite difficult to defend?
I can see some pros of having something that deals with principle, because the way you were left it was that leasing does have a very large role to play in terms of bits of the law that originally had an EU focus. But the reason why that's often helpful from a legal certainty perspective is it sort of makes quite clear in a lot of cases what the actual answer is. And as I was saying in my little bit, sort of leasing, obviously it comes from EU law. It has a sort of EU constitutional driver to it. But when you're applying it, you're not just thinking of it in terms of what does Europe think. You're looking at what the purpose of the actual duty or the right or the obligation is in substantive terms. And that's where it has its sort of real impact, and I think where it can become a case changer in terms of its application. So it's something, if the government intend to reverse that leasing approach in terms of where courts look and where the courts look at purpose and where they look for purpose, then that would need to be done on an overarching basis at that constitutional level. I think there are problems in terms of practicality, in terms of how that then works actually in practice. And it is, in those terms, a very radical thing to be doing. I still haven't quite got my head around this reverse leasing principle. but it seems to sort of work at that sort of constitutional level without having any of the content of what the purpose of the duty is. So I'll reserve my position on what that actually ultimately ends up being, but I can see a case for doing something constitutional. It's just how you then do it is tricky, but others might well disagree.
Right. Does anyone have any additions to that? We are just past our time, so if you do have any contributions, if they can be relatively brief. You may not say anything at all if you want to. Andrea.
Very briefly, I think that anything can be changed, anything can be, can actually improve, and that's not the point. I think that probably, at least from a legal standpoint, legal point of view, is just the method. That because exactly what we just discussed, that this bill is going to have such a big impact on any area of the law. It's not just about EU law, whatever. This is really entrenched principles that are now part of the common law of the British legal system. That this is the method that perhaps does raise some concerns. It's not the fact that you want to change things. That's fine. And again, Katherine just mentioned leasing, but again, are we going? The bill says no more application of the general principle of EU law. Fine. Are we going to start questioning again the relevance of the principle of proportionality or the principle of effectiveness within domestic law? They're there. So it's just, I'm slightly amazed that we don't simply take a sensible, practical approach. That certain things are now part of the domestic legal system. Full stop.
Right. Okay. Well, I think we'll end it there, if we may. Can I give my heartfelt thanks to Katherine, Alison, and Andrea, and I'll wish you, ladies and gentlemen, good evening. Good evening.